Gina Naknak, and today I want to talk about two very hot topics during this time, which is employment law as it relates to COVID and civil rights laws. So joining me today is Jim DeSimone, the founder of V. DeSimone Law, a Los Angeles-based litigation practice based in Marina del Rey, litigating civil rights cases, including employment, police brutality, and personal injury. He is a top 100 Southern California super lawyer, one of the top employment attorneys in California as recognized by the Daily Journal, and is considered one of Los Angeles' best civil rights attorneys by his peers. So you can find James at www.thejamesdesimonelaw.com. So Jim, thank you so much for joining me today.
Thank you for inviting me, Gina. Great to see you.
Absolutely, great to see you as well. So I'd really love to start on the topic of employment law. Can you kind of explain to us what some of the most common violations of employment law that you're seeing that are coming up related to COVID?
Well, related to COVID, we have companies that aren't necessarily providing reasonable accommodations to their employees. I mean, I think we're all trying, right? We have this new situation where all of a sudden the world turned upside down and people were told to shelter in place. How do you run a business if you don't have your employees there? And we have certain types of businesses, of course, that have remained open with essential workers where people have to be there. But I think what companies are finding out is that people can work remotely. And where the tension is coming in is now that we have the laws relaxing and where businesses are allowed to open, companies are saying, come on into the office, but people are saying, wait, not so fast. They might have a disabled family member. There's associational disability, for instance. If I have somebody at home that's at greater risk for contracting COVID-19, I may not want to go into a workplace where I might be exposed to it and get somebody sick with this disease that could actually kill them. So people are requesting reasonable accommodations of working from home. And that's a good request. I think the companies in that instance should do their best to allow their employees to work from home and get the job done. I think when the advent of COVID-19, I mean, we're now like 3 months in, right? It's seemingly, it started in March. What I saw is a lot of companies, they laid off people too, right? And they fired people. And some of those were a natural result. But there are payroll protection programs to protect companies from losing the money they would pay on salaries if they're not making as much profit. So I found my phone's kind of ringing off the hook. People getting fired and say, wait a minute, I'm getting fired, but I made a complaint about harassment and they just fired me. Or I've always been discriminated against. This is an all-male company and they let the only woman go or the only African-American employee go. And so in that case, COVID was used as a cover for discrimination.
Wow.
And so we have had a number of cases where I've been able to step in and negotiate. And companies have at times been willing to at least compensate that person for their wrongdoing instead of facing a lawsuit, which ultimately, if they don't come to grips and negotiate with me, that's what we do. We're trial lawyers and litigators.
Mm-hmm, mm-hmm. So if someone feels as though they have been discriminated against in this way, like the examples you mentioned, what should they do?
Well, I always think you go back to the basics. When someone gets a job, they're often asked to sign off on a number of different things. And they want the job. Where do I sign? And they sign. But 9 times out of 10, what they're signing is they're acknowledging receipt of a company handbook. Now, it used to be they'd actually hand you a company handbook, but not anymore. Now they have access to the handbook and the policy and procedures of a company online. So the first thing I always tell people to do is look at what is the protocol in the company you're working for, because most companies do have, at least on paper, really good anti-discrimination provisions, an avenue for people to make complaints. And indeed, if you're being discriminated against, you have an obligation, believe it or not, as an employee to follow the company's policy in bringing that discrimination to the company's attention. It's called, the technical term is called avoidable consequences. What does that mean? Well, if you're getting harassed by your boss at a bigger company, and the company says, we don't tolerate any harassment, in order to avoid the consequences of that harassment, complain to the company and at least give the company the opportunity to do the right thing. Now, this has an advantage in two ways. One, legally, you're protected because you've made the complaint. And two, hopefully the company ends up doing the right thing. But if they don't, and they retaliate against you, which does happen, right? Some companies, they might have it on paper, but they don't follow through on what they should under the law. Then at least you've made a legally protected complaint. And especially, I always encourage people to put that complaint in writing. And why is it so important to put it in writing? One, it's evidence. When we as trial lawyers go into trial, what's our evidence now? I'm putting emails up on the board, that's our evidence. And, and it is very powerful when I have an employee, a client, who expresses themselves well in that written email and they're reasonable, to show that to a jury, and then look what the company did. They ignored that or they retaliated against them. There's an old saying, dance like nobody's watching. Maybe you heard it. And if anybody saw me dance, they would know. They'd say, yeah, you should. Nobody should watch. No, but dance like nobody's watching. But email as if it will be read aloud in court someday. So when you're writing this email, make sure, and this goes for anything, right? Not, to anybody, don't do it in anger. Something happens, anything, there's also the old saying, right? Anything you say can and will be used against you. If you are coming across as a hothead or angry or unreasonable, it's very hard for even an experienced employment lawyer like me to bring that case to a jury, because these cases a lot of times turn on likability factors. There's the law, but then ultimately we're all human beings, and jurors want to know who's the good guy, who's the bad guy, so you want to comport yourself that way as an employee. Even if internally you're angry because you were hurt, because someone hurt you, and we use our anger to mask that hurt. I always tell my clients I can get a lot better compensation for them by showing that they were hurt than showing that they were angry. So write that email in a way that, one, is factual, set forth the facts, set forth very simply and plainly what you'd like the company to do within reason, especially in terms of a reasonable accommodation. And also, as a point of emphasis, tell them how much you value the job. Tell them how much, show what contributions you've made to the company. Tell them you want a long future with the job. Emphasize those things. Those types of things will look golden if you have to go to litigation. Of course, this advice is hopefully geared towards making people avoid lawsuits. I always tell people, you're better off with a job than a lawsuit. When we grow up, nobody ever said, what do you want to be when you grow up? Oh, I want to be a plaintiff in an employment litigation lawsuit, right? I want to be a doctor or a lawyer. Nobody says, I want to sue and hit the litigation lottery, right? But that being said, when there's wrongdoing, we do have a great system of justice, especially here in California, where people can get reputable attorneys such as my law firm or the many other firms that practice this area of the law, and hold the employer accountability for that wrongdoing. you just as an employee want to put yourself in the best possible position when you do that. So every step along the way is important.
Yeah, thank you. That's some great tips because um, somebody might be experiencing that and maybe just boiling over with anger, and then until things just kind of come to a head. But it's important to note that if you're kind of experiencing this kind of discrimination or you feel it happening, it is important to, like you say, go back to reference that employee handbook, see what the proper protocol is, document your complaint in writing, and structure it in such a way that it can be useful if and when it is used in court someday. And maybe would you even suggest in CCing your personal email on that message to HR or whoever it is, so that you can maintain.
Well, I would personally think it's probably better to blind CC your personal email
Yeah.
or forward it to yourself. You don't want to CC an outside lawyer. You want to make sure that if you're communicating with an attorney, never do it from a work email. They can always read your email. So when someone's communicating with me, if you're communicating with a lawyer and you feel that you need to communicate with a lawyer, that's attorney-client privileged. Well, so that what we say is private. That's, that it's pretty sacrosanct, that, that can't be pierced. But if someone's using a work email, that attorney-client privilege goes out the window. Believe me, you have signed something. There's an expectation that the company can read your emails. And so you want to be careful about that as well. But yes, I mean, there's a fine line. I think forwarding emails and so on, there is some case law in California that if you're downloading proprietary files of a company to set up a case, that can get you in trouble. So, you want to be careful about, you want to protect yourself with evidence, maybe print it out, or something like that, but you don't want to be downloading massive amounts or anything significant, because believe me, the employer will figure out that you've done that, and then you're looking like you're doing something wrong. And there's some bad case law against employees that show that, that it is considered not to be okay.
Yeah, absolutely. Definitely, should be trending carefully there, and always consulting the advice of attorney. I think when in question, right? So, if you guys want to reach out to Jim, I'm again going to link his website below. It is vjamesdesimonelaw.com. So you can always reach out to him there.
Yeah, we have a place on the website where people can ask questions, and believe it or not, I'm not the only one, but I read those questions. And there are times, I mean, it's hard to always respond, we in real time, to obviously, because if I'm doing that, I'm not getting the real work done that I need to for my clients. But I've developed some, if a case seems like it has potential, I will respond even late at night, and people really appreciate that. And, it is something, I would say I think as an attorney, I'm someone who does go above and beyond for my clients and even potential clients. I live this life of being a lawyer for the people and to represent people who have been hurt. And I've been doing it for, over 3 decades. So it really is, I like to have a good time, but it's part of who I am, right? So it's a calling. And, in those instances, it may be difficult at times for people before they write that letter to the company to get an attorney to review that email. So if you can't get an attorney to review it, get someone you trust, get somebody, how does this come across? Because it's not only how it's going to look in court, but if your email is persuasive or your communication is persuasive, you're also likely to get a better outcome with your boss, with the company. But if you're seen as someone who's angry and who's just, looking for trouble, then, your chances for success within the company are lower, and your chances for success in terms of vindicating your rights in a court of law are lower as well. So you really want to take your time. in this culture right now, we have this thing with direct messages and with our texting and everything that we got to respond immediately. Like so, and I do it too. Something comes in, okay, I'm responding before I'm thinking. Right? What's the rush? What happens if you respond tomorrow? Wouldn't you rather have a reasoned, well-measured response within 24 hours than within 2 minutes? You know?
Yeah, absolutely. So important to consider, right? To make sure that you're in the right state of mind so that you can make sure that your communication is really crystal clear. And I love that tip that you give about not only making the complaint, but to also reiterate what is it that you're looking to have changed. What is it that you're asking for, right?
Right. And that's especially important when we're talking about individuals who need a leave or are disabled and are asking for reasonable accommodations. Um, there is a responsibility on the part of the employer, and then it comes on to the employee to engage in what's called the interactive process. So the interactive process is if you're looking for a reasonable accommodation at work, what we were talking about, if you have some disability that prevents you, let's say, disability is a very broad term under California employment law. All it has to do is interfere with the major life function. So let's say someone has asthma, right? I mean, you're not disabled in the sense that people may think about someone who's disabled, but asthma can interfere with the major life function of breathing. And people who have asthma could be at higher risk for bad results. I mean, of if contracting COVID-19. So if you have a condition like this, people with diabetes, they are more susceptible to harm. So if you're asking for that reasonable accommodation, you as an employee are also required to engage in that interactive process, to meet, to write, and to actually communicate what you want. So it really plays into your what helps you under the law. And what's really important is the employers have that obligation to engage in that interactive process. So if you see it one-sided and the employee is asking, okay, well, this is what I can do, this is how I can do my job. Had a client who said, look, I can do my job remotely. Look at this. Already developed a whole protocol of how I could work remotely, and here it is. And the company's like, no, sorry, you can't see the clients, we're firing you. Well, this one I can't talk about because we're in pre-litigation, but I'm in a position to negotiate a pretty good settlement for that person because they conducted themselves in a way that really showed the company how they could do the job with reasonable accommodations. And the company, without engaging in that interactive process, just arbitrarily fired them. So that sort of thing is really important, rather than having kind of a defeatist attitude and thinking, they're not going to do anything, so what? It's like, okay, if they don't, they don't, but at least you tried and you were reasonable on your side.